Okay, let's dive into this. Welcome to today's Explainer, where we are tackling a seriously powerful legal concept, absolute liability. Today, we're going to unpack exactly how this uncompromising legal doctrine holds massive, hazardous industries completely accountable for their actions. We've got a great roadmap for you today. We'll start by defining what this concept actually means, then look at the historical tragedies that brought it to life, and finally, we'll explore its modern, real-world applications. So let's kick things off by setting up the foundational legal concept we're exploring today. In simple words, absolute liability is basically the rule of strict liability, just totally stripped of any loopholes or exceptions. In India, this doctrine actually evolved through the landmark case of MC Mehta v. Union of India. The facts of that case were pretty grim. Oleum gas leaked from an industry in Delhi, affecting a massive number of people. Ultimately, the Supreme Court held the defendant liable without even considering the usual exceptions that would apply under standard strict liability. You can think of it like a strict equation. If a person carries out an inherently dangerous or hazardous activity, plus any harm is caused during an accident, that equals absolute liability. Period. There are absolutely no exceptions. This is the exact same rule that was notably followed in the devastating Bhopal Gas tragedy case, which we'll touch on in a second. So what actually forced the Supreme Court to evolve this law? That brings us to the historical catalyst. To really understand this, we have to look at the high-stakes reality of India in the mid-80s. You had two back-to-back tragedies. First, the 1984 Union Carbide Bhopal leak, which horrifically killed over 3,000 people. Then, just a year later, in December 1985, oleum gas leaked from Shrimram Foods and Fertilizers Industries in Delhi, killing a lawyer and affecting many others. A public interest litigation was filed, and the terrifying reality was this. If the old strict liability exceptions applied, these hazardous industries, located right near populated areas, would essentially escape scot-free. Faced with that immense pressure, the Supreme Court had to act. Listen to this powerful quote. Law needs to be kept changing according to the needs of the society. Law cannot afford to remain static. Chief Justice P.N. Bhagwati actually coined the term absolute liability, right here, because the legal system literally had to adapt to protect citizens from modern industrial destruction. Now, let's look at the direct legislative aftermath of these massive industrial disasters. To make sure victims get quick relief in the future, the Public Liability Insurance Act of 1991 was passed. Let's break this down. It mandates that anyone carrying out hazardous activities must have public liability insurance in place. This fund is based entirely on the principle of no-fault liability, meaning strict and absolute liability. And it is comprehensive, covering any substance that can seriously harm humans, animals, plants, property, or the environment. So how exactly does this differ from the old rules? Let's contrast strict and absolute liability. Now, what's really interesting about this slide is how brilliantly it illustrates the absolute lack of wiggle room for corporations. Look at applicability. Strict liability applies to persons, but absolute liability targets commercial enterprises, similar to how an employer is responsible for a worker's injury no matter who caused it. Under strict liability, you have several defenses and exceptions, like an act of God or a third-party act. Under absolute liability, zero defenses, none. You are guilty. Also, notice the escape row. In strict liability, the dangerous element had to literally escape the premises. In absolute liability, escape isn't even necessary. Harm to the workers right inside the premises triggers full liability. And that brings us to the financial impact, which is a real game changer. Under strict liability, compensation just matches the actual damage. But under absolute liability, the compensation is designed to be a massive deterrent. It is exemplary in nature. The financial penalty must actively exceed the actual damages, calculated based on the enterprise's scale and financial capability. It is specifically designed to hurt financially, to prevent mass death and environmental destruction. Let's move to and see how this builds into modern legal practice today. By adopting absolute liability, India effectively modified the Old English rule from Rylands v. Fletcher. Today, industries get no defense, the escape element is dropped, and the compensation is exemplary. To show you the modern financial stakes of this, take a look at this massive figure, 50 crore rupees. That 50 crore was the penalty handed down by the National Green Tribunal to LG Polymers. Here's the tragic real-world context. On May 7th, toxic gas leaked from their Visakhapatnam plant and spread over 3 kilometers, affecting 5 whole villages. 11 people, including a child, lost their lives. The tribunal held the company absolutely liable and explicitly rejected their review petition against that massive penalty, cementing the absolute liability of the enterprise. There were no excuses. To wrap things up, absolute liability is a stricter, completely exception-free rule. It was designed from the ground up to hold hazardous industries fully accountable and to heavily deter future harm. But I want to leave you with this final, provocative thought to ponder. As our economy grows and industrial technologies become even more complex, is the uncompromising hammer of absolute liability the only way to truly ensure the safety of our society? Thanks for joining me on today's Explainer. I'll